On June 12, 2026, a federal judge in Texas issued a 4-page order that every private gun seller in America needs to understand. Judge Matthew Kaczmarek of the United States District Court for the Northern District of Texas vacated the ATF's 2024 Engaged in the Business rule nationwide and made one thing unmistakably clear. Defendants may not apply the final rule to anyone, including individuals and organizations who are not parties to this case. Not just the plaintiffs, not just Texans, anyone, everywhere. Then, on July 10, 2026, 4 weeks after that ruling, the Department of Justice filed a motion asking the same judge to walk it back. The fight is not fully over. And by the end of this video, you are going to understand exactly what the rule was, why the court killed it, what the DOJ is trying to do about it, and what your legal status as a private seller is right now. Let me start with the statutory foundation, because you cannot understand what the 2024 rule did wrong without understanding what the law actually says. The Gun Control Act of 1968 required anyone engaged in the business of dealing firearms to obtain a federal firearms license, maintain records, and conduct background checks. But it did not precisely define where the line fell between a commercial dealer and a private citizen selling personal property. In 1986, the Firearms Owners Protection Act fixed that. FOPA defined engaged in the business as a person who devotes time, attention, and labor to dealing in firearms as a regular course of trade or business with the principal objective of livelihood and profit through the repetitive purchase and resale of firearms. FOPA also explicitly protected a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection. That was the standard for 36 years. To be a dealer, dealing firearms had to be your livelihood. Occasional sellers, hobbyists, and collectors liquidating personal property were protected by statute. In 2022, the Bipartisan Safer Communities Act changed one phrase. It replaced with the principal objective of livelihood and profit with to predominantly earn a profit. That change removed the livelihood requirement. Under the new statutory text, a person whose predominant intent in selling firearms is to make a profit, even if firearms dealing is not their livelihood, potentially meets the threshold for dealer status. The BSCA retained the personal collection and hobby exceptions, but stripping the livelihood requirement created a gray zone. Collectors who turned a profit selling duplicates, hobbyists who sold to fund new purchases, people upgrading their home defense setup and selling the replaced firearm. All of them were now in uncertain territory. The Biden ATF stepped into that gray zone in April 2024 and pushed it as far as it could go. The 2024 rule promulgated 4 specific provisions that the court later found unlawful, and each one is worth understanding precisely because they are the legal basis for the entire vacatur. The first unlawful provision, the rule eliminated any minimum number of transactions as a prerequisite to being engaged in the business. Under the rule, a single firearm sale could potentially trigger the FFL requirement if the seller's intent was to profit. The court found this directly contradicted the GCA's language requiring a regular course of trade or business, which implies pattern and repetition. One transaction is not a business. The second unlawful provision, the rule turned the licensing requirement on a predominant intent to earn a profit rather than requiring any showing of actual profit. The court found this created an unworkable subjective standard, allowing the government to assert profit intent with no objective threshold to constrain the determination. The third unlawful provision, the rule excluded firearms acquired for personal protection from the long-standing personal collection exception. Selling a home defense firearm you were replacing could now be deemed a sale from outside your personal collection, potentially triggering dealer status. The court found this directly contradicted FOPA's explicit protection for persons who sell all or part of his personal collection. The fourth unlawful provision, the rule created rebuttable presumptions of profit intent and dealer status, including a presumption that persons selling at gun shows, selling online, or engaging in repetitive transactions were operating as dealers. The court found these presumptions impermissibly shifted the burden of proof onto gun owners and collectors to disprove dealer status, reversing the traditional legal presumption that lawful private conduct is protected unless the government proves otherwise. Those four provisions, taken together, had a single practical effect. They placed millions of ordinary gun owners in legal jeopardy for conduct that had been explicitly protected by federal statute since 1986. The human cost of that jeopardy arrived before the rule was even finalized. In March 2024, ATF agents raided the home of Brian Malinowski, the executive director of Clinton National Airport in Little Rock, Arkansas, on allegations that he was selling too many firearms at gun shows without an FFL. During the raid, Malinowski reached for a firearm. A TF agent shot him. He died 2 days later. He had been selling approximately 150 firearms at gun shows over several years, keeping records in a notebook and reinvesting profits into additional purchases. He believed he was operating within the personal collection exception. The ATF believed he had crossed the engaged in the business line. Under the vague standard the 2024 rule produced, both of them could point to the same law and reach different conclusions. That is what unworkable regulations produce. Malinowski paid for that ambiguity with his life. Now let me walk you through what happened to the rule in court. Kildi naro arsein for or undoing so. Cur. Because the procedural path to the June 12th ruling is part of the story. A coalition of states, Texas, Louisiana, Mississippi, and Utah, joined by Gun Owners of America, the Tennessee Firearms Association, and the Virginia Citizens Defense League, filed suit in May 2024 challenging the rule under the Administrative Procedure Act. In June 2024, Judge Kaczmarek granted a preliminary injunction, finding the plaintiff substantially likely to succeed on all four of the unlawful provisions. That injunction halted nationwide enforcement of the rule. The Biden DOJ appealed to the Fifth Circuit. When President Trump took office, the new DOJ dropped the appeal in April 2026. The ATF then opened a new rulemaking to voluntarily rescind the challenge provisions and asked Kaczmarek to pause the case while that process played out. He refused. He denied the stay, granted summary judgment to the plaintiffs on the APA vacatur claims, denied the government's cross motion, dissolved his own preliminary injunction as unnecessary, and entered final judgment vacating the entire rule. Judge Kaczmarek's order quoted the Tennessee Firearms Association directly. Congress writes statutes. Agencies administer them. When an agency attempts to transform lawful conduct into regulated conduct by bureaucratic decree, it must be challenged. And defeated. Under the Administrative Procedure Act, a court that finds agency action unlawful shall hold unlawful and set aside that action. Kaczmarek applied that standard. The rule was vacated, not stayed, not remanded for revision. Vacated, set aside, gone. Then came July 10th. The DOJ filed a Rule 59E motion, a motion to alter or amend the judgment, filed with the same Judge Kaczmarek who issued the ruling. Not an appeal to the Fifth Circuit, a direct challenge to the scope of the remedy in the same district court. The DOJ's argument, the 2024 rule contained an explicit severability clause, stating that if any provision is found unlawful, the rest of the rule should survive. The DOJ argues the court should have severed only the four unlawful provisions and vacated only those, leaving the remainder of the rule standing. The nationwide vacatur of the entire rule, including provisions the court did not specifically analyze, was, in the DOJ's characterization, a manifest error in the scope of the remedy. The plaintiff coalition will file a reply. Judge Kaczmarek will have to rule on his own judgment a second time. Here is what matters for your compliance picture right now while that motion is pending. The entire rule remains vacated. A Rule 59E motion does not restore the vacated rule pending its resolution. The motion asks the judge to amend the judgment going forward. It does not reinstate the rule during the briefing period. As of today, the 2024 ATF engaged in the business rule cannot be enforced against anyone. Let me give you the compliance bottom line precisely. The vacatur means the 4 unlawful provisions are gone. The personal collection exception is restored to its pre-rule scope. The presumptions of dealer status are gone. There is no minimum transaction number the ATF can enforce through the now vacated rule. What the vacatur does not mean, the underlying statute is unchanged. 18 U.S.C. Section 922A(1) or on A still makes it a federal felony, to 5 years in prison, to engage in the business of dealing firearms without an FFL. The vacatur removed the ATF's unlawful regulatory expansion of what engaged in the business means. It did not remove the underlying criminal prohibition. Private sellers who genuinely operate as commercial firearms dealers, repeatedly buying and reselling as a regular course of trade with the predominant intent to profit, are still required to hold an FFL under the BSCA amended statutory standard. The vacatur restored the legal line to its pre-rule position. It did not eliminate the line. One final piece. The ATF's replacement rulemaking is in progress. A proposed revised rule was published in the Federal Register on May 6, 2026, with a public comment period open. A future version of this rule is coming. Any replacement rule will have to stay within the statutory boundaries the court identified. It cannot reinstate the 4 specific provisions Kaczmarek found unlawful without a new legal theory that survives APA scrutiny. But the regulatory effort to define the engaged in the business line more broadly than FOPA and the BSCA support is not permanently dead. It is temporarily defeated. If you sell firearms occasionally from your personal collection without a predominant profit motive as your regular course of business, today's legal standard does not require you to hold an FFL. If you are uncertain where your activity falls, the fact-specific nature of the engaged in the business analysis means there is no substitute for a licensed attorney's review of your specific situation. The consequences of getting it wrong remain a federal felony. The rule is gone. The underlying law is not.